Welcome to a special deep dive designed to help you ace your RES exam. This is our Case Studies deep dive.
Hello, everyone.
Our mission today is really to unpack some real-world examples. We're looking at sources you've shared, focusing on those key lessons for anyone thinking about entering the real estate industry.
That's right. We've got three quite fascinating case studies lined up. They really highlight crucial rules, ethical considerations, things you absolutely need to know.
Yeah, we're going to get into the details, understand what went wrong, and really grasp the key takeaways.
Stick with us as we dive in.
And hey, before we jump right in, if you find this deep dive helpful for your studies or your practice, please take a moment to like it and subscribe to the channel.
Yeah, it really helps us out and ensures you don't miss any of our future deep dives.
Okay, let's get started. Case study 1. This one's about a personal assistant posing as a RES.
Right. This really draws a clear line between sort of admin help and regulated real estate work.
Okay, so the situation. A registered RES engages a personal assistant for admin tasks. Seems pretty standard, right?
Totally normal on the surface. The RES was Peng Junyoung, but here's where it's problematic.
What happened?
Well, Pang gave his property listing portal account details the user ID, the password, to his personal assistant.
Whoa, okay. Sharing professional logins like that?
Yeah.
That feels like a significant issue from the start.
It absolutely is. And it didn't stop there. The account details were actually changed to show the assistant's name and contact number.
Seriously? So it wasn't just access, it was active misrepresentation.
Exactly. Then, under Peng's instructions, this assistant started posting rental ads on the portal, and crucially, representing himself as a RES in those ads.
Okay, so impersonating a registered agent online, instructed by the actual agent, that's bad.
It gets worse.
Yeah.
The assistant even contacted another genuine RES to try and co-broke some room rental transactions.
And that's how it came out. The other RES likely flagged it.
That seems to be part of it, yeah. Investigations eventually revealed the assistant held himself out as a RES multiple times. He even managed to successfully facilitate a lease transaction.
All while not being registered.
Correct, despite not being registered at all.
So the outcome, what were the consequences?
Well, Peng Junyoung, the actual RES, was convicted of abetting the assistant, essentially helping him commit the offense. He was fined $12,000.
Okay, a hefty fine for Peng and the assistant.
The personal assistant was convicted of holding out as an estate agent and salesperson. His fine was even higher, $20,000.
Wow. Okay, so significant penalties. What's the big industry insight here? What principle are they protecting?
This case really hammers home the importance of RES registration under the Estate Agents Act. We're talking sections 28 and 29 specifically. The absolute core policy intent here is consumer protection.
Consumer protection. How does the registration itself achieve that?
Well, holding yourself out as a registered RES when you're not is a clear violation. It doesn't matter if the assistant was acting under instructions, the act itself is the problem. Right, but the really crucial layer, especially for the public, is professional indemnity insurance, PII.
Ah, the insurance aspect, like needing a driving license for car insurance.
Exactly that analogy. You must be a registered RES to be covered by the estate agency's PII. And unregistered assistant's actions, they're simply not covered.
So if a consumer suffers a loss because of this assistant's misrepresentation,
there's no PII payout, no safety net through that channel. Their only recourse might be a civil case against the assistant directly, which is, often long, difficult, and not guaranteed.
that makes sense. So sections 28 and 29 aren't just red tape. They ensure the person doing the work is registered, knowledgeable, and crucially insured. It protects people in complex transactions.
Absolutely. So for you listening, this clarifies that boundary. Admin help is one thing, scheduling, filing, sure, but referring clients, negotiating, representing yourself as an agent, that's regulated work, only for a registered RES.
A really clear takeaway there. Always verify you're dealing with someone registered and insured. Okay, let's move to case study 2. This one involves refusing to co-broke and false advertising.
Yeah, this touches on professional conduct between agents and honesty in marketing. The RES here is Tae Wei Leong.
So Tae advertised a property. Another agent, let's call her RES A, had a keen buyer, buyer B, RES A, contacted Tae about a viewing and asked about co-broking.
Right. And Tae's initial response was apparently a bit cagey about the co-broking part, didn't really address it directly.
Okay.
Then buyer B sees another ad for what looks like the same property but with a different address. So buyer B contacts Tae directly about that ad.
Wait, a different address. Deliberately misleading.
That's what the findings indicate. When Buyer B asked, Tay falsely blamed the portal, saying it generated the wrong address. But the investigation found he had intentionally put in a wrong postal code.
Wow, okay. So a deliberate attempt to perhaps get buyers to contact him directly, bypassing their agents?
Seems very likely. Tay told Buyer B he knew she was represented by RESA and he'd sort the matter out with her.
But did he?
No. Despite saying that, he arranged and conducted 2 viewings directly with Buyer B, no RESA involved, no notification to her.
That really sounds like trying to keep the full commission, cutting RESA out.
The Buyer B even mentioned to Tay that RESA deserved something if the deal went through. Tay just repeated he'd sort things out.
Which he didn't.
Correct. After Buyer B got the option to purchase, RESA finally managed to reach Tay. Tay then claimed B was a direct buyer, no co-broking involved. He vaguely mentioned maybe paying RESA something out of goodwill.
Yeah, goodwill. That probably never materialized. So RESA complained.
Understandably, yes. And the outcome for Tay. He was convicted by a CEA disciplinary committee on 3 charges, fined $14,000, and suspended for 7 months.
14 grand and a 7-month suspension. That's serious. What specific rules did he break?
Breaches of the Code of Ethics and Professional Client Care, the CEPCC. First, paragraph 6.3, failing or refusing to co-broke fairly. Second, also paragraph 6.3, failing to even discuss remuneration for RESA with his CEO, his agency head, like he promised the buyer he would.
Right.
And the third, paragraph 12.4, causing a false or inaccurate advertisement with that dodgy postal code.
So it's a pattern. Unfairness to a colleague, breaking promises, and dishonesty in advertising. What's the bigger lesson here?
It really underscores that for a seller's agent, being open to co-broking isn't just ethical, it's usually best for the seller wider pool of buyers, right? Refusing or avoiding it harms industry professionalism.
And the false ad was key to his strategy.
Absolutely. That inaccurate listing directly led the buyer to him, giving him the chance to bypass RESA. Plus, not honoring his promise to the buyer about sorting things with RESA, that erodes trust everywhere. Actions like this damage the whole industry's reputation.
Yeah, definitely. So for you listening, this case shows why co-broking is generally expected. It serves the client. It screams the importance of honesty in ads. Even a postal code matters. And it highlights ethical duties not just to clients, but to fellow professionals.
Very well put. Okay, our third and final case study today. This one focuses on handling transaction monies, a very strict rule area.
This involves a salesperson, Ko Hong Kim, getting rent payments put directly into his personal bank account.
Yeah.
And he did this by, well, deceiving the tenant.
Yes, this one is particularly troubling due to the calculated deception involved. Ko was managing a lease. Initially, everything was fine. Tenant paid rent directly to the landlord's account. Standard practice.
Right, the correct way. So what changed? Why the deception?
Ko sent a false WhatsApp message. He claimed the landlord complained about late rent, which wasn't true.
Okay, starting with a lie.
Then he followed up by falsely saying the landlord wanted rent paid into a new bank account. For convenience, made up excuses about the landlord having trouble walking, using internet banking. He explicitly told the tenant this new account was the landlord's.
But it wasn't the landlord's account, was it?
No. It was Ko's personal bank account. The landlord never complained, never asked for a new account, never wanted rent paid to Ko. The tenant, unfortunately, believed him and started transferring rent into Ko's account from August 2021.
Unbelievable. And what did Ko do with that money?
He used it for his father-in-law's medical expenses, but the deception didn't end there.
There's more.
Yes. He later lied again, claiming the landlord wanted advance rent. He even offered a fake $100 discount as bait. The tenant paid the advance rent, too.
And that money also went missing.
Used for his father-in-law's medical and then funeral expenses? The whole thing fell apart when the tenant eventually realized the landlord wasn't getting paid and filed a police report.
Rightfully so. Did he pay it back?
He did make full restitution and compensation, but only after the police got involved.
After he was caught, essentially. What was the legal outcome?
Ko was convicted in the state courts. He faced 6 charges under Regulation 71B of the estate agency work, regulations for unlawfully holding transaction monies. He pleaded guilty to 2 charges, fined $14,500 total, $7,250 per charge.
A significant fine again.
Yes. And the source mentions he wasn't even a registered salesperson anymore by the time of conviction, but the offenses happened while he was registered, so the prosecution proceeded.
This case just screams the importance of that fundamental rule about handling money, doesn't it?
It absolutely does. The key insight is about professional standards, the code of ethics, duty to protect clients, treat everyone honestly, and the absolute non-negotiable rule.
Nah.
Salespersons are strictly prohibited from handling transaction monies. Rent, deposits, option fees, anything related to the sale, purchase, or HDB lease in Singapore. Zero tolerance. It should never go into their personal account.
And it's not just on the agent to refuse.
Exactly. Consumers, clients, tenants, you should never give transaction money directly to a salesperson or pay into their personal account, no matter the story they tell you. Pay the landlord, pay the seller, use the proper channels like lawyers' escrow or HDB systems.
This rule is clearly there to stop exactly this kind of fraud and misuse of funds.
Precisely. It protects everyone, ensures transparency, prevents financial misconduct. Agents must maintain honesty, integrity. This case is a stark reminder. It also subtly points to why things like ongoing CPD, continuing professional development, are important, keeping agents up to date on these critical rules.
So for you, the listener, why is this ban on handling money so vital? It's your primary protection against fraud and misuse of large sums. It ensures funds go where they're supposed to, safely and verifiably. Always use the correct channels, never through the agent's personal account.
Okay, let's try and pull together the main lessons from these three cases. Looking back, what really stands out?
Yeah, diving into these specifics really shows why the rules exist. It's not just theory.
Definitely. So first, case one, the personal assistant. It hammered home that RES registration isn't just admin. It's fundamental for consumer protection, ensuring knowledge, and crucially, PII cover. Dealing with someone unregistered is a risk.
Right. Then case two, Taewei Leong refusing to co-broke and the false ad. That really showed the code of ethics isn't optional. Treating colleagues fairly, being honest in ads non-negotiable. Integrity is key.
Absolutely. And thirdly, case three, Ko Hong Kim and the rent money. That highlighted the absolute strict ban on salespersons handling transaction monies. No gray areas. It's there to protect everyone, especially the consumer, from potential misuse of funds.
So taken together, these cases really drive home the importance of integrity, transparency, and just operating strictly within the rules, the legal and ethical framework. It's not just about avoiding fines.
No, it's about building a professional practice based on trust, essential for long-term success.
Wow, yeah, going through those really does ground the rules in real consequences.
They certainly do. We've seen how things like poor supervision, deception, unfair practices, mishandling funds, they lead to serious penalties and destroy trust.
Understanding these examples isn't just about avoiding pitfalls, is it? It's about actively building your practice on integrity and protecting consumers, whether you're studying for the exam or already working.
Exactly. It's about building that solid foundation for your career.
Definitely. So here's a final thought for you to maybe mull over after hearing these cases.
How does proactively understanding these ethical lines and legal rules, knowing these real-world consequences, actually change how you might approach interactions? With clients, with other agents?
Could knowing this stuff help you spot potential problems before they happen, maybe even prevent issues from arising at all?
Something to think about. Keep learning. Stay informed.
And thank you for joining us for this ACE Your RES Exam Case Studies Deep Dive.